On March 18, 2022, Gevo Incorporated entered into a fuel supply agreement with British Airways, pursuant to which Gevo has agreed to supply 30 million gallons per year of sustainable aviation fuel to BA. Under the agreement, Gevo will deliver to BA SAF produced at one or more of Gevo's SAF production facilities that are currently being developed. BA will pay Gevo based on an index price, plus an additional price per gallon. Under the agreement, the parties allocate between themselves certain environmental attributes generated in connection with the SAF. The agreement became effective on March 18, 2022 and will continue in full force and effect until the 5th anniversary of the commercial operations date of Gevo's production facilities, unless earlier terminated pursuant to its terms. The parties may terminate the agreement in the event that certain conditions precedent related to the financing and development of the SAF production facilities are not met, if Gevo is unable to deliver the minimum annual contract quantity of SAF under the agreement, or if certain customary events of default or other circumstances occur and are not cured within a certain time period. Upon the termination of the agreement due to an event of default, the non-defaulting party will be entitled to remedies at law or equity, subject to customary limitations on liability contained in the agreement. Such remedies may include covered damages for replacement SAF, which could be significant. The agreement contains certain customary representations, warranties, covenants and confidentiality provisions, and also contains mutual indemnification obligations. All SAF delivered by Gevo shall meet the quality specifications established in the agreement. The foregoing description of the agreement does not purport to be complete and is subject to, and qualified in its entirety by, the full text of the agreement, a copy of which is attached hereto as Exhibits 10.1 to this current report on Form 8-K and are incorporated herein by reference. Article 1. Scope 1.1. Subject to and in accordance with the general terms and conditions that are incorporated herein by reference and attached hereto as Annex I, the general terms and conditions, seller agrees to sell and deliver or cause to be sold and delivered, and buyer agrees to purchase, pay for and receive, or cause to be received, the SAF for consumption in buyer's aircraft as set forth herein. As set forth in greater detail herein, seller will deliver SAF at the applicable off-airport storage facility, where such SAF will be blended with jet fuel. 1.2. In the event of an irreconcilable conflict between this fuel sales agreement and its annexes, and unless expressly stated otherwise, the following rules shall apply. This agreement shall prevail over Annex I, save that, if Annex I addresses a topic not expressly addressed in the agreement, then Annex I shall prevail in relation thereto and its provisions shall not be diminished by the agreement. Subject to the foregoing, to the extent that this agreement supplements the requirements prescribed in Annex I, no conflict shall be deemed to exist, and the provisions of this agreement and Annex I shall be read cumulatively. 1.3. All headings and titles in this agreement are used for editorial facilitation and shall not be interpreted as affecting or influencing the meaning, content or substance of its provisions. 1.4. All annexes to this agreement shall constitute an integral part hereof and shall further be subject to the terms of this agreement. Reference to the agreement shall be understood to include reference to all its annexes, whether or not explicit mention thereto has been made in other parts of the agreement. Article 2. Term and conditions precedent. 2.1 The startup period and the delivery term constitute the term of this agreement. 2.2. The startup period shall be the period beginning on the completion date and continuing until the commencement date, the startup period. 2.3. Unless otherwise agreed in writing by the parties, the delivery term of this agreement shall commence on the commencement date and, unless sooner terminated as provided here, shall continue for a term the delivery term, of 5 years. 2.4 The following terms shall have the respective meanings. Commencement date means the date specified by seller in a written notice to buyer, furnished not less than 60 days prior to such date, that seller has determined in its reasonable discretion that seller's facilities have achieved commercial operation and are able to produce and deliver SAF purchased pursuant to this agreement. The commencement date shall be no earlier than January 1, 2025 unless otherwise mutually agreed by the parties. Completion date means the day that seller determines in its reasonable discretion the seller's facilities are substantially complete, all required facility testing has been completed pursuant to the relevant EP contract, and the seller's facilities are ready to be used for the production of SAF. Seller's facilities means one or more facilities for the production, refining and delivery of sufficient unblended SAF having a maximum CI score of ... to be developed and constructed by seller at its sole expense. Seller shall make good faith efforts to review methods of reducing the CI score of the unblended SAF delivered hereunder. The parties agree that the selection of the location for the seller's facilities shall be the decision of the seller, and that any and all other costs, cost differentials or other economic impacts stemming from such decision shall be the responsibility of and borne entirely by the seller. 2.5. Notwithstanding anything to the contrary herein, seller shall not be obligated to deliver any SAF under this agreement unless and until all of the conditions precedent set forth in this section 2.5, the conditions precedent, shall have been satisfied, or waived with prior agreement in writing with buyer, as determined by seller in its sole discretion. Thereafter, seller shall be obliged to deliver the SAF as per the provisions hereof. A. Seller shall have obtained all governmental and regulatory authorizations for development of seller's facilities and production and delivery of SAF as required by this agreement, including all necessary approvals to supply SAF to the applicable delivery point, an approved RFS pathway, and a valid provisional or final LCFS fuel pathway code, and shall have provided written notice of the same to buyer. B. The completion date has occurred, and seller's facilities are completed and producing SAF. 2.6. Seller shall use commercially reasonable efforts to cause the completion date to occur no later than January 1, 2026, as may be extended, the target completion date. The target completion date shall be subject to an extension on a day-for-day basis for each day that the achievement of the completion date is delayed by a force majeure event or by acts or omissions of buyer, provided that the target completion date shall not be extended by reason of a force majeure event by more than 365 days. Prior to the completion date, seller shall promptly provide a copy to buyer of any written notice of any material violation of any applicable law relating to any seller's facility or its design, construction, operations, or commissioning received by seller during such time period. Seller shall provide buyer with notice of the completion date at least 60 days prior to the completion date. As set forth in section 2.2, the startup period shall run from the completion date through the commencement date. 2.7. The target commencement date shall be the date 12 months after the completion date. From and after the satisfaction or waiver of all of the conditions precedent, seller shall use commercially reasonable efforts to cause the commencement date to occur no later than the target commencement date. Prior to the commencement date, seller shall promptly provide a copy to buyer of any written notice of any material violation of any applicable law relating to any seller's facility or its design, construction, operations, or commissioning received by seller during such time period. 2.8. Notwithstanding any contrary provision hereof, if the conditions precedent have not been satisfied, or waived, by the target commencement date, buyer shall have the right to cancel this agreement, without any liability of buyer or seller arising therefrom, on not less than 30 days prior written notice to seller. 2.9. Seller shall keep buyer reasonably informed as to the status of seller's development and construction of seller's facilities, including providing regular updates, not less frequently than quarterly, commencing no later than 2 years prior to the expected commencement date. Seller shall provide buyer with notice of the commencement date at least 60 days prior to the commencement date. 2.10. Notwithstanding anything to the contrary in this Article 2, if financial closing with respect to all financing necessary for seller to proceed with the construction of seller's facilities has not occurred on or prior to December 31, 2023, then either party may cancel this agreement, without any liability of buyer or seller arising therefrom, on not less than 30 days prior written notice to the other party. Article 3. Key terms. 3.1. During the term, buyer agrees to purchase and receive, or cause to be received, and seller agrees to sell and deliver, no less than the minimum annual contract quantity at the delivery point at the price set forth herein. 3.2. Seller and buyer agree that all obligations of buyer under this agreement to purchase and take delivery of the minimum annual contract quantity shall be on a take or pay basis, such that buyer shall pay for and receive, or cause to be received by a third party, or pay for even if not taken, all SAF delivered, or tendered for delivery, in the case of SAF not taken, by seller to buyer at the delivery point under this agreement up to the minimum annual contract quantity, on condition that, in tendering such SAF, seller has complied in all material respects with its obligations hereunder and subject to the conditions herein, including without limitation with all specifications stipulated for the SAF, its blending and blended output. 3.3. SAF specifications. The physical specification for blended SAF delivered by seller to buyer pursuant to this agreement is fuel compliant with ASTM Standard Specification D1655. The physical specification for unblended SAF purchased by the buyer pursuant to this agreement is D7566 Annex 5, Standard Specification for aviation turbine fuel containing synthesized hydrocarbons as in effect on the effective date. Article 4. Pricing, Contingency Account. 4.1 Pricing shall be as set forth in this Article 4. 4.2 The price for soft sold to buyer hereunder will be ... 4.3 Delivery and blending costs shall be payable as set forth in Article 6. 4.4 In lieu of providing credit support hereunder, the parties have agreed that buyer will pre-fund an account for ... days of SAF deliveries hereunder. Accordingly, prior to the completion date, seller shall establish an account, the contingency account, which shall be available to pay any amounts due and owing by buyer hereunder in the event that buyer fails to make payment when due on any undisputed invoice issued hereunder. Within 10 days of buyer receiving from seller the notice of commencement date in accordance with Section 2.9 and a report by a mutually agreed independent engineer that the seller's facilities are complete and ... away from the commencement date, buyer shall pay to the contingency account by wire transfer of immediately available funds an amount equal to the price that would be due and payable for ... US gallons of SAF if such SAF were delivered on the completion date, i.e., using the pricing formula in Section 4.2 above. If at any time the balance in the contingency account is more than 10% greater than what would be required to fund the contingency account for the next ... days, based upon the pricing then in effect under Section 4.2 for ... US gallons of SAF, seller shall apply a credit in the amount of such excess on the next invoice issued hereunder. If at any time the balance in the contingency account is more than 10% less than what would be required to fund the contingency account for the next ... days, based upon the pricing then in effect under Section 4.2 for ... US gallons of SAF, seller shall invoice buyer for such deficiency and buyer shall promptly, but in no event later than 5 business days after receipt of seller's invoice, fund to the contingency account by wire transfer of immediately available funds an amount equal to such deficiency. Seller agrees to apply all deposits in the contingency account solely towards payments due by buyer hereunder, provided that notwithstanding anything to the contrary herein, seller shall have the right to pledge, hypothecate, or assign the contingency account and any cash or assets on deposit in, or credited to, such account, free from any claim or right of any nature whatsoever of buyer. For sake of clarity, in the event that seller draws on the contingency account in order to pay an invoice due and owing by buyer hereunder, such payment shall not constitute a cure of any event of default under Section 11.1 of the General Terms and Conditions unless and until buyer shall have remedied any deficiency in the contingency account resulting therefrom. After the end of the term and the resolution of all outstanding amounts due and owing hereunder, seller shall transfer the balance in the contingency account to buyer. Article 5. Allocation of emissions credit revenues. 5.1 blank. 5.2. Within 30 days following the end of a calendar quarter during the term, ... any amounts due and owing from seller to buyer shall be reflected as a credit on the next invoice issuable to buyer, provided that if such an amount becomes due and owing after the final settlement of all amounts payable by buyer hereunder, seller shall pay the cash equivalent of such amounts to buyer. 5.3. If any applicable law is enacted, implemented, modified, amended or revoked so that the implementation of the agreement becomes impossible, impracticable or materially inconsistent with the terms or requirements of this agreement and or the general terms and conditions, including any changes to government programs associated with the emissions credits or the availability of user-specific credits under CORSIA, the parties shall work in good faith to amend the agreement to conform to the changed requirements or circumstances in order to maintain the original intent of the parties hereunder and the economic conditions set forth herein. Article 6. Delivery and seller's responsibilities. 6.1. Unless otherwise expressly agreed in writing by the parties, all deliveries of unblended SAF shall be to one or more off-airport storage facilities servicing the following airports, off-airport storage facilities, as specified by the buyer. 6.2. Seller shall provide written notice to buyer identifying the off-airport storage facilities where seller will deliver SAF. Delivery of SAF shall occur. The delivery point. 6.3. Seller shall, on buyer's behalf, and in accordance with this agreement, applicable laws and applicable industry standards, provide, or cause to be provided, transportation of all quantities of unblended SAF to be delivered hereunder from the seller's facilities to the applicable off-airport storage facility associated with the specified delivery point and, 2. Blending of the SAF with conventional jet fuel at the off-airport storage facility. The seller shall at all times retain risk and title of the SAF until delivery at the delivery point. All costs incurred from seller's facilities to the delivery point, the delivery and blending costs, shall be for the account of seller. 6.4. Seller shall further be responsible for securing all permissions and authorizations needed for the blending of the SAF with conventional jet fuel and for the conduct and output of such blending according to the standards and specifications agreed herein. Without prejudice to the generality of the foregoing and without the scope of the foregoing being deemed reduced, seller shall also be responsible for securing recertification, approval of the blended output, including product gains recertification, after blending. 6.5. If buyer nominates a third party or affiliate as the recipient of SAF purchased by buyer, then seller's obligations hereunder shall also apply for such SAF delivery. Article 7. Minimum annual contract quantity. The minimum annual contract quantity shall be, a. During the startup period, a volume of SAF that seller is able to produce and deliver from seller's facilities on an as available basis to the applicable off-airport storage facility for blending with jet fuel, with such volume not to exceed 30 million US gallons of SAF per year on a ratable basis and, b. During the delivery term, 30 million US gallons of SAF per year. For sake of clarity, while the parties recognize that SAF delivered hereunder will be a blended mix of jet fuel and unblended SAF, for all volumes of blended SAF delivered hereunder by seller, seller shall have delivered to the applicable off-airport storage facility for blending with jet fuel an equivalent volume, at 15 degrees Celsius, of unblended SAF. If seller makes available to buyer SAF in excess of the minimum annual contract quantity, buyer shall have the right to purchase such SAF on the same terms and conditions as set forth herein other than with respect to price, which will be subject to written agreement of the parties. For sake of clarity, buyer shall have no obligation pursuant to this agreement to purchase any SAF in excess of the minimum annual contract quantity, and seller shall have no obligation to provide such SAF. All sales of SAF by seller in excess of the minimum annual contract quantity shall be on an as available basis, and seller shall have no obligation to offer any SAF to buyer in excess of the minimum annual contract quantity even if seller has such SAF available. If, for any reason, seller's facilities are incapable of producing sufficient SAF to deliver the minimum annual contract quantity of SAF, then seller shall allocate the SAF produced from seller's facilities ratably among all of seller's customers without discrimination, provided that seller shall have no obligation to allocate to buyer production from the facilities currently under development by seller known as Net Zero 1 and Net Zero 2. Seller shall use commercially reasonable efforts to develop sufficient capacity at seller's facilities to ensure delivery of the minimum annual contract quantity. Article 8. Invoicing and payment terms. Unless otherwise agreed in writing by the parties, the following shall apply. 8.1. Seller shall issue a monthly invoice based on shipments of SAF delivered to buyer under this agreement, which shall contain the following information: a. The volume of SAF purchased in the applicable shipment. b. The price per US gallon of SAF. c. A description of applicable taxes, fees or other charges. d. Total amount due on the invoice. e. The date of the shipment. f. The delivery note reference. g. A copy of the proof of sustainability document for the applicable SAF manufactured by any seller's facility and subsequently purchased by buyer. h. The delivery ticket document to evidence supply of the SAF to the delivery point and I. Any other information buyer may reasonably request in advance, in particular to support buyer's claim of ownership of its Scope 1 emissions reduction associated with its purchase of SAF. A delivery note must accompany each invoice. A sample invoice, including attachments, and proof of sustainability document is set forth in Annex 2. 8.2. Invoices shall be sent via email to ... 8.3. Invoices for SAF delivered or deemed delivered to companies for which buyer is acting as an agent only shall be sent directly to the agreed company without any involvement of buyer, unless otherwise directed by buyer in advance in writing. 8.4. Invoices shall be issued and payment shall be effected in United States dollars. 8.5. The payment terms shall be as follows. A. Payment by buyer on each invoice shall be net at the latest of 10 days from the date of receipt by the buyer of an accurate invoice complying with the requirements of sections 8.1 and 8.2 above. Payment shall be made by wire transfer of immediately available funds in United States dollars. Details about the seller's banking information are set forth in section 8.6 below. B. Absent manifest error, buyer shall pay all disputed and undisputed amounts due under each invoice without netting or offsetting. In the case of manifest error, the correct amount shall be paid disregarding such error, and necessary correction and consequent adjustment shall be made within 5 business days after agreement of the correct amount. C. If a party invoiced and received payment of a sum subsequently determined not to have been payable under this agreement, such party shall pay interest to the other party on such amount on and from the date when such sum was originally paid and including the date of its repayment at a rate, the interest rate, equal to ... Any amount not paid by a party when due shall bear interest from and including the date payment was originally due to and including the actual date of payment at the interest rate. 8.6. Payments shall be transferred to the seller's bank account as provided for in the applicable invoice. Article 9. Insurance. 9.1. Until all obligations under this agreement are satisfied, and without limiting seller's indemnification obligations under the agreement, seller shall procure and maintain the following insurance policies from insurers with an AM Best rating of B+VI or a comparable rating. A. Workers' compensation covering obligations imposed by federal and state statutes with jurisdiction over sellers' employees and employers' liability insurance of at least ... B. Commercial general liability insurance with a minimum limit of ... per claim for bodily injury or death and broad form property damage. The policy shall cover bodily injury, property damage, personal injury, products and completed operations, and broad form contractual liability coverage including, but not limited to, the commercially insurable liability assumed under seller's indemnification obligations set forth in the agreement. C. Business automobile liability insurance with a limit for bodily injury and property damage of a minimum limit of ... each occurrence with respect to any and all vehicles of sellers, whether owned, hired, leased, borrowed, or non-owned, assigned to or used in connection with seller's performance of the agreement, and D. Environmental impairment liability insurance with a limit and annual aggregate of ... which shall include coverage for all actions, omissions, or active or passive negligence, for bodily injury, property damage, defense costs and environmental remediation costs with respect to releases of hazardous substances at any seller's facility, including SAF prior to delivery. 9.2. Additional insureds. Except for workers' compensation, all the policies required in this Article 9 shall name buyer and its affiliates as an additional insured whether in its/their capacity as buyer or as a reseller of the SAF. 9.3. Primary. The policies shall stipulate that the insurance required by this Article 9 shall be primary insurance and that any insurance or self-insurance carried by buyer shall not be contributory insurance. 9.4. Recovery rights. Seller shall waive, and require its insurers to waive, any and all recovery rights to which any insurer of seller may have against the buyer by virtue of the payment of any loss under any insurance. 9.5. Maintenance of insurance policies following termination or expiration. To the extent that the insurance policies required under this Article 9 are not occurrence-based policies, except for workers' compensation, seller shall maintain claims-made policies for at least 3 years following termination of the agreement. 9.6. Severability of interest. All policies required under this Article 9 except for workers' compensation, shall contain a severability of interest provision, and shall not contain any commutation clause or any other provision that limits third-party actions over claims. 9.7. Evidence of insurance. Upon buyer's request, seller shall provide documentary evidence in a form and content acceptable to buyer, confirming to its satisfaction that the required insurance policies have been obtained and will remain in effect as required by this Article 9. 9.8. Notice of material changes. Seller shall provide buyer with at least 30 days written notice prior to any material changes in or cancellation of any insurance policies. Article 10. Governing law. The validity, construction and performance of this agreement shall be governed by New York law without giving effect to any choice of law provision or rule, whether of the state of New York or any other jurisdiction, that would cause the application of the laws of any other jurisdiction. Article 11. Disputes. The parties shall attempt to resolve any disputes under this agreement through negotiation prior to resorting to other dispute resolution mechanisms. If the parties are unable to do so after using reasonable good faith efforts, the federal or state courts situated in New York County, New York, United States of America, have exclusive jurisdiction over the resolution of all disputes that arise under this agreement, and each party irrevocably submits to the personal jurisdiction of such courts. The United Nations Convention on Contracts for the International Sale of Goods shall not be applicable to the parties' rights or obligations under this agreement. Article 12. Financing cooperation. Without diminishing seller's obligations and buyer's rights hereunder, buyer acknowledges that seller may elect to finance all or part of its costs of the transactions contemplated by this agreement, including the costs of the construction of seller's facilities. Buyer shall use commercially reasonable efforts to provide all cooperation reasonably necessary in connection with any financing efforts that seller may undertake in connection with financing seller's facilities, as may be reasonably requested by seller, provided that such efforts shall not, I, relieve seller of any of its obligations under this agreement. 2. Decrease the economic benefits, or increase the costs, of the transactions contemplated by this agreement to buyer, or 3. Create increased economic or legal risk to buyer in connection with the transactions contemplated by this agreement. In furtherance of the foregoing, buyer agrees to negotiate in good faith and in a commercially reasonable manner a customary collateral assignment for security purposes of this agreement for the benefit of such persons providing such financing, as may be reasonably necessary and appropriate for such financing, provided that none of the terms of such consent shall, I, relieve seller of any of its obligations under this agreement. 2. Decrease the economic benefits, or increase the costs, of the transactions contemplated by this agreement to buyer, or 3. Create increased economic or legal risk to buyer in connection with the transactions contemplated by this agreement. Article 13. Assignment. 13.1. Neither party may assign its obligations under this agreement, in whole or in part, without the prior written consent of the other party, which consent shall not be unreasonably withheld. Buyer or seller may, however, assign its obligations to any of its affiliates without the prior written consent of the other party, provided that in such event, but subject to section 13.2 below, assigning party shall be jointly and severally liable for the performance by such affiliate of the agreement. 13.2. Notwithstanding the foregoing, seller may, without the prior written consent of buyer, assign this agreement in part to any person acquiring all or substantially all of the assets comprising any seller's facility. B. Collaterally assign this agreement to any person providing financing or other security in connection with any seller's facility. C. Assign this agreement in connection with a lender's exercise of remedies under an applicable credit agreement related to the financing of any seller's facility, or D. Assign this agreement to any affiliated special purpose vehicle in connection with a financing related to production of SOF in connection with this agreement. The seller shall advise the buyer of any such assignments in this clause no later than 10 days after any assignments, and in the case of an assignment contemplated in sections 13.2a or 13.2d, the assigning party shall ensure that the assignee, X, complies with clause 2 of Annex I and Y, is a fit and proper party that is demonstrably capable, including by contracting for same with a capable third party, of meeting its performance obligations under this agreement and operating the applicable seller's facility IEs and coordinating downstream logistics and blending using good industry practice, meaning the exercise of skill, diligence, prudence and foresight that would reasonably or ordinarily be expected from a skilled and experienced operator in the fuel refining and transportation industry engaged in the same or similar type of undertaking. With respect to any assignment pursuant to sections 13.2a or 13.2d, the assigning party shall be released from all obligations and liabilities under this agreement. Article 14. Public announcements. Seller and buyer agree to publicly disclose, via a mutually agreed upon press release, aspects of the commercial plan for buyer to serve as a purchaser of SAF from seller's facility at such time as seller and buyer shall mutually agree at their respective unfettered discretions, save that, as a condition precedent for such disclosure/publication, each party shall coordinate with and shall receive the written consent of the other party with respect to such disclosure/publication, and shall so provide advance copies to the other party for review of the text of any proposed announcement/publication prior to the dissemination thereof to the public or to any person other than employees, consultants, representatives, agents, advisors, contractors or subcontractors of any tier, who agree to keep such information confidential. Notwithstanding the foregoing, either party shall be permitted to make any and all required disclosures of the agreement and the transactions contemplated thereunder in accordance with the rules and regulations of the U.S. Securities and Exchange Commission, SEC, or any other regulatory body or securities exchange, including, but not limited to, filing the agreement with the SEC in connection with a Form 8-K, 10-Q or 10-K, albeit to the extent that may be so required, subject to the right of the other party and its counsel to review copies of any such proposed filing or filings in advance thereof and comment thereon, and the obligation of the disclosing party to consider in good faith any comments reasonably requested by the non-disclosing party or its counsel in such filing or filings or with respect to the redaction of trade secrets or competitively sensitive information contained therein. Article 15. Counterparts. This agreement may be executed in multiple counterparts, each of which when so executed and delivered shall constitute a duplicate original and all counterparts together shall constitute one and the same instrument. Buyer shall only be bound by this agreement upon its execution and return of such executed counterpart to the seller. The parties acknowledge and agree that any document or signature delivered by facsimile, PDF or other electronic transmission shall be deemed to be an original executed document for the purposes hereof, and such execution and delivery shall be considered valid, binding and effective for all purposes.